Okay, this is CPL 170.15.1.2. Now there's 1 through 5, but I'm going to split this into 2 or 3 videos. So the first one, I wrote it to code, just so that the language and the idea is very clear, okay? This particular section, 170.15, is removal of action from one local criminal court to another, okay? And this particular section, as I discussed in the previous video, is dealing with all the informations plus misdemeanor. That's information, simplified information, prosecutor's information, misdemeanor complaint, no felonies. Okay, so, excuse me. Police officer arrests defendant for an offense other than a felony committed in a city or town, not brought before a particular local criminal court, which by reason of the situs, that means where legal action can be taken, of such offense has trial jurisdiction thereof, but instead, for whatever reason, he can't take it to the court where it's supposed to go, so the LCC where it's supposed to go, but instead before an LCC which does not have trial jurisdiction. And that LCC, such LCC, must arraign him upon such accusatory instrument. If defendant desires to enter a plea of guilty following such arraignment, such LCC must permit him to do so and must conduct the action to judgment. Otherwise, it must remit the defendant with all papers and documents to the LCC, the original LCC where they should have been taken, who has trial jurisdiction of the action, and I can't read what, and the latter court must then conduct such action to judgment or other final disposition, right? So the police officer, for whatever reason, can't take him to the LCC that has the jurisdiction, trial jurisdiction, takes him to another LCC for the arraignment, and then if he wants to enter a plea of guilty, he can do that. And this is city or town. Just repeating it. Okay. Otherwise, if that's not the case, otherwise it must remit. Otherwise, it must send that defendant to the original court where he should have gone in the first place to conduct such action to judgment or other final disposition. Okay. That's number 1 of 170.15. Number 2. For a Supreme Court judge sitting as a lower criminal court, it's a lot shorter. It's going to basically be same kind of language. He's going to arraign. So again, this is when the police officer is not taking him where he's supposed to be taken, but he's taking him to this court with the Superior Court judge sitting as an LCC. He's going to arraign him. Then he must remit the action with the papers and documents, same process, to LCC with trial jurisdiction. And the latter court, as above, they're going to do the same thing. Latter court, is going to conduct such action to judgment and order and other final disposition. Okay? So same as above. Right? Now, the reason that it's shorter is because the Supreme Court judge sitting as an LCC does not take pleas, okay? So the defendant can, if he wants to plead guilty, he cannot do it there. So he's just gonna, he's gonna arraign him, but then he's gonna send him off with the papers where he should have been going in the first place. Okay, I'm gonna do another video for 170.15.3 and 4, so you don't wanna miss it. Tune in.